Hello students, this is Miss Michaud and this is your contract laws assignment. First of all, please create a Google document. I'd like you to name it your last name, contract law. Number the sheet as follows. Number 1, homecoming. Number 2, is an agreement a contract? Number 3, Twin Pines. Number 4, revocation. Number 5, pocket calculator. And number 6, water beds. Throughout this presentation, you will be required to stop the screencast and answer some questions under those 6 items. When finished answering the questions, please submit your document on the appropriate link on Google Classroom. Okay, so let's get started. Learning targets. Students will be able to define contract, list at least 5 contracts they will encounter in their lives, describe at least 5 classifications of contracts, list 5 types of contracts that must be in writing to be enforceable, which is referred to as the Statute of Frauds, describe the 6 elements of contracts, and describe different types of contracts. What is a contract? It is any agreement enforceable by law. Have you entered into a contract? When you purchase something at a store, that is a contract. It is an implied contract. You are saying with your actions, I am willing to pay this amount for this product. An implied contract is a contract that comes about from the actions of the party. Contracts. What is a contract? This video will give you some insight into this topic.
In this video, we'll discuss what we mean by a contract. When you think about contract law, first, think about promises. But these are promises recognized as legal obligations by a court. And if this legally recognized promise is broken, a court might impose liability on the party breaking the promise. Now, people make promises all the time. For example, I promise to meet you next week. Don't worry, I promise you it won't rain. But with contracts, remember, we're concerned with liability if the person breaks a promise. If your friend doesn't show up in the park as scheduled, we don't expect a court to make someone pay for not showing up on a date. Likewise, maybe your friend promised you that it wouldn't rain, but you're probably not going to sue your friend because her weather prediction was wrong. Without even studying the law, instinctively, we don't expect your friend's weather prediction to be a legally enforceable contract. On the other hand, if we have a promise to sell a scooter in exchange for money, and one party pays money but there's no scooter, well, that seems to be a broken promise for which we expect there to be some liability. So what's the difference then between a broken promise to be someone's best friend and a broken promise to sell or to buy a scooter? When should a promise be part of a contract, a legally enforceable agreement? We can say that a contract is made of distinct pieces that we'll call elements. And if we have the necessary elements, we have a contract. You can think of elements of a contract the way you might think of ingredients to a soup. If we have the right ingredients, we can make our soup. But now we're asking, what do we need? What are the elements to form a contract? And generally, our 3 elements for a contract are offer, acceptance, and consideration. Before we can have a contract, we should have these 3 elements. We'll say the offer and the acceptance are a mutual agreement to enter into a deal. And consideration will mean the parties are giving and getting something. For example, paying money in exchange for a painting. And we'll need all 3 elements to have a contract. This course focuses primarily on the offer, but in subsequent courses, we'll be looking at the acceptance and consideration. So our basic definition of a contract is going to be a promise that a court will enforce. Put a slightly different way, it's a promise that if broken, can result in liability. You can also define a contract as an agreement that can be enforced in court. If you'd like to discuss contract law or any other matter related to U.S. law, stop by my website and feel free to send me an email.
Great, that's information about contracts. Remember, a social obligation or an agreement is not a contract. Okay, so number 1, homecoming. Connie Adler agreed to go to the homecoming dance with Fred Wolf. Later, Steve McNamara, the captain of the football team, asked Connie to be his date for homecoming. Connie broke her date with Fred, poor Fred, to go to the dance with Steve. Does Fred have a legal claim against Connie? Why or why not? Please answer this question on your sheet. Oops. Went one too many there. All right, so the answer is no. This was a moral or a social obligation. There was no consideration, so no valid contract existed. So please modify your answer on your handout. And let's take a look at this particular one, number 2. Is an agreement a contract? And this was a real case. In the August of 1994, Jared Hyman purchased a $9,033 diamond engagement ring. He then asked Heather Parrish to marry him. She said yes and took the ring. About a year later, in October 1995, Mr. Hyman broke off the engagement. Mr. Hyman asked Ms. Parrish to return the ring to him, but she refused. Mr. Hyman then sued her to retrieve the ring. Ms. Parrish argued to the court that an engagement ring is a part of a contract between two parties to get married at a later date. She argued that Mr. Hyman broke off the engagement, breached the contract, and could not recover the ring. Mr. Hyman argued that the proposal and engagement were not a binding contract, but rather a statement the parties would get married. The ring was a conditional gift to Ms. Parrish, which Ms. Parrish could keep if the two got married. Since the two did not get married, Mr. Hyman had no right to recover the ring, and that's his claim. So was there a contract between Mr. Hyman and Ms. Parrish? Please record your answer on your sheet. Answer. The Kansas Supreme Court found that there was no contract when gifts such as engagement rings are given in contemplation of marriage. You should review the 6 components of a contract, which are offer, acceptance, genuine agreement, consideration, capacity, and legality. While a marriage constitutes a legal and binding contract, an engagement does not. There is no communication to the offeree of the circumstances under which the ring would be returned. There is no unconditional acceptance on the part of the offeree, and therefore, there is no genuine agreement. So Mr. Hyman's out of luck. He loses his engagement ring. There are many contracts that you will encounter in your life. Here are some examples of a few. Implied contract to buy goods or services, employment contract, a loan contract, also called a promissory note, a contract to buy real estate, such as mortgage, contract to rent an apartment, which is referred to as a lease, a contract to rent a car, and a marriage contract. The 6 elements of a contract consist of offer, acceptance, consideration, capacity, genuine agreement, and legality. Let's take a look at these. An offer is a proposal by one party to another intended to create a legally binding agreement. For example, I'll sell you my pen for $5. 2. Acceptance is the second party's unqualified willingness to go along with the first party's proposal. Okay, I accept your offer as is. Genuine agreement, an agreement that is true and genuine. A valid offer is met by a valid acceptance. Capacity, the legal ability to enter into a contract. In other words, both parties must be legally competent. Consideration is the exchange of benefits and detriments by the party to a contract. So in the first example, I'll sell you a pen for $5. The pen and the $5 are the consideration. And 6, legality. Parties are not allowed to enforce contracts that involve illegal acts. A little more about an offer. An offer is a proposal by one party to another intended to create a legally binding agreement. The offeror is the person making the offer. The offeree is the person who receives the offer. The 3 basic requirements of an offer include: it must be definite and certain, it must be communicated to the offeree, and it must be seriously intended. Here's an example. Number 3, Twin Pines. The Galaxy Research Center emailed an offer to the owners of Twin Pines, a farm in rural Arkansas. The email message stated, "Please consider this our offer to purchase between 9,000 and 11,000 acres of your 15,000-acre tract of farmland near Twin Pines, Arkansas. Our offering price is between $15,000 and $19,000 per acre. Please respond ASAP." Is this email message a legally effective offer? Why or why not? Please return to your sheet and answer this question now. Feel free to hit the pause button while you do so. Answer: the email is not legally an effective offer because the terms are too vague. Between 9,000 and 11,000 acres is not concrete. It's not specific enough. Between $15,000 and $19,000 is also too vague. Let's learn about an invitation to negotiate. It's often confused with an offer. An invitation to negotiate are invitations to deal, trade, or make an offer. Sellers usually have limited merchandise to sell and cannot possibly sell an advertised product to everyone who sees the ad. So ads in newspapers are considered invitations to negotiate, not real offers. For this reason, most advertisements in newspapers, magazines, and catalogs are not treated as offers, but rather as invitations to negotiate. If customers say they would like to buy an advertised item, they are actually making an offer to buy the item at the advertised price. The store owner is free to accept or to reject the offer. Acceptance of an offer is effective as soon as the acceptance is sent. The revocation or the taking back of an offer is effective when it is received. Let's take a look at what is meant by the mailbox rule.
In this video, we will discuss the contract law mailbox rule. The mailbox rule tells us that the acceptance of an offer is effective as soon as the acceptance is sent. The mailbox rule applies to letters and to deliveries. The mailbox rule does not apply to phone calls, and there's a question as to whether it should apply to emails. So let's say Ali posts an offer, and he offers to care for lawns at $100 a week, and he requests acceptances by April 10th. Fred decides that this is a good deal, so he sends a letter back to Ali. And on April 9th, he accepts Ali's offer. That same day, on April 9th, he properly mails the letter. Ali receives Fred's letter on April 12th, but Ali asked for the acceptance by April 10th. Ali and Fred probably have a contract. Fred sent his acceptance to Ali on April 9th. The mailbox rule tells us that as of April 9th, the offer was accepted. In fact, let's say Fred sent his acceptance on April 9th, but the letter somehow disappeared. So Ali never received the acceptance. Fred and Ali probably still have a contract. The mailbox rule tells us that Fred's acceptance was effective as of April 9th. So let's say Ali decides to revoke his offer on April 8th. And on April 8th, he sends a letter saying he revokes his offer. Fred receives Ali's letter on April 10th. Fred and Ali should still have a contract. Fred sent his acceptance on April 9th. Ali's attempt to revoke the offer was only effective as of April 10th when it was received. The mailbox rule only applies to acceptances, not revocations, counteroffers, or anything else. According to the mailbox rule, the offer was accepted on April 9th. Ali's attempt to revoke the offer came too late. If you'd like to discuss further, please visit my website and blog, and feel free to send me an email.
Okay, so that deals with the revocation of an offer. Let's take a look at this apply and debate question number 4, revocation. Victor Archer mailed an offer to Sally Miles. Sally mailed a properly addressed and stamped letter of acceptance 10 minutes before she received a revocation from Victor. Was the revocation effective? Defend your position by citing which legal principle is involved and how it applies. Please pause this and place your answer on your sheet. The answer is no, the revocation was not effective. If an offer is accepted in the same manner of communication as it was made, the contract is binding as soon as acceptance is met. In other words, it was accepted before it was revoked. Remember, revocation means they take back an offer. Please double check your answer and correct it before we move on. Acceptance. Acceptance is the second party's unqualified willingness to go along with the first party's proposal. The acceptance must be unconditional and must follow the rules regarding the method of acceptance. There is something that is referred to as the mirror image rule. The terms stated in the acceptance must exactly mirror or match the terms of the offer. A counteroffer is a response to an offer in which the terms of the original offer are changed. The offerer now becomes the offeree. So if I tell you I'll sell you my pen for $5 and you say I'll give you $2, that's a counter offer. Consideration is the exchange of things of value. In an offer to let someone borrow a car, there is no consideration in the agreement if nothing is offered in return. So you just ask, can I borrow you a car? That's not a contract. Let's learn a little bit more about consideration.
In this video, we will discuss consideration and the formation of a contract. Consideration is one of 3 elements that are needed to make a contract. Elements are like ingredients. Think of the ingredients you might need for a soup. And if we're missing and changing ingredients, then we don't have soup. Our elements, or ingredients, for a contract are offer, acceptance, and consideration. An easy way to understand consideration is that each party has to give something and get something. And just make sure that what a party is giving is not something that party already has to do. For example, let's say Peter asks Sally to paint his fence, and Sally says no. That's not a problem. Sally doesn't have to paint anybody's fence. And Peter doesn't have to pay anybody if he doesn't want to. But Peter's fence is not going to get painted. Now let's say Peter and Sally agree that Sally will paint Peter's fence for $100. Now we have a contract, because now we have an offer, an acceptance, and consideration. Peter is promising to do something he doesn't have to do, but pay $100. And in return, Sally is promising to do something she doesn't have to do, paint his fence. Each party is giving something, and each party is getting something in return. Keep in mind that the amount of consideration in the United States usually does not matter. Let's say Sally asks Peter to paint her car in return for $5. A court will probably not worry whether or not $5 is enough consideration. Each party is promising to do something in exchange for the other party's promise. And if we have an offer, acceptance, and consideration, we have a contract. If you'd like to discuss contracts or any other matter related to U.S. law, stop by the message board and please visit my blog. Also, feel free to send me an email and to send me your comments below.
Okay, so consideration is one of the elements of a contract. It's what one gets or gives in the contract. The exchange of things of value. One person may offer to drive another person to work one morning, and the other might accept. Such an arrangement would have offer, acceptance, and agreement, yet it would not be a contract. If the offeror has a driver's license, owns his car to which he has proper access, and had the appropriate mental capacity to make such an offer, the agreement would have capacity and legality, but still would not be a contract. Only when one sort of payment, monetary or not, or promise of payment flows from the passenger to the driver, which would be referred to as consideration, would it be a contract. Remember, contracts must have offer, acceptance, and consideration. Genuine agreement is another element of a contract. It is an agreement that is true and genuine. In other words, a valid offer is met by a valid acceptance. What circumstances can you think of that would destroy the genuineness of an agreement? Fraud, if somebody committed fraud, misrepresentation of something, a mistake. In other words, you offer to sell something and you transpose the numbers. Undue influence. One person has extraordinary power over another. Or economic distress, in which one party is taking advantage of financially. Capacity is the legal ability to enter into contracts. Whenever people negotiate the terms of a contract, they assume that everyone has the power or capacity to do so. Several types of people might have the right to disaffirm or get out of contracts, such as minors, people with mental impairments, and people under the influence of drugs or alcohol. Legality is another element of a contract. The contract does not entail violating the law. It should not. It will not be enforced. Statute of Frauds requires that certain types of contracts be in writing to be enforceable. These types of contracts include, number 1, to pay someone else's debt. Number 2, to pay debts of a person who has died. Number 3, contracts requiring more than a year to perform. Number 4, contracts in consideration of marriage. Number 5, contract for the sale of goods over 500. And number 6, contracts to sell real estate. Question number 5, pocket calculator. Bob Goodman made a verbal agreement to buy a pocket calculator from Howard Herman for $35. When Herman delivered the calculator, Goodman refused to accept it, stating that he was not bound by his verbal agreement. Was Goodman correct? Why or why not? Please place your answer on your sheet now. No, an oral agreement involving a small amount of money is enforceable if it meets all the other requirements of a valid contract. Remember, the Statute of Frauds states that amounts over 500 must be in writing to be enforceable. So this was under 500, so the oral agreement is still enforceable. There are different types of contracts. An implied contract is a contract that comes about from the actions of the parties. An express contract is a contract statement that may be oral or written. A unilateral contract is a contract that contains a promise by only one party to do something, if and when the other party performs some act. A bilateral contract is a contract that contains two promises. This is the most common. One party promises to do something in exchange for the other's promise to do something else. Void, an agreement that is not valid. It is missing one or more of the required elements of a contract. Valid is a legally binding agreement containing all 6 elements of a contract: offer, acceptance, consideration, genuine agreement, capacity, and legality. Voidable is when a party is able to void or cancel a contract for some legal reason. Unenforceable is an agreement the court will not uphold, generally because of some rule of law or statute of limitations. Here's an example of a unilateral contract. Remember, a unilateral contract is a contract that contains a promise by only one party to do something, if and when the other party performs some act, such as offering a reward for a lost cat. If you return the cat, you should get the $250. A breach of contract occurs when one or more of the parties fails to fulfill their contractual duties. That's a breach of contract. There are many different ways to terminate an offer: revocation, rejection, counteroffer, expiration of time, death, or insanity. Let's learn a little bit more about terminating an offer.
Now, when does an offer extended by an intended party to a contract, when does it expire, or when is it no longer capable of being accepted by the offeree, the person to whom the offer is extended? Well, there are a number of situations. It could be that there is a specific provision in the offer. For example, I say you have 5 minutes to tell me if you will buy my coat for $10. Okay, I've made you an offer to sell my coat for $10, and my condition is that you have to accept within 5 minutes. If you don't accept within 5 minutes, then the offer is terminated because that specific provision terminated the offer. Another situation could be a reasonable lapse of time. That is, I simply throw out an offer to you. Now, what a reasonable person in your position would believe to be a reasonable amount of time given the nature of the offer. Okay, if I were offering to sell you my coat, a reasonable time period for you to accept that offer, maybe 5 days, maybe 10 days, maybe 30 days, it depends. But if I offer to sell you bananas, the time period for accepting that offer is much shorter. So in that situation, it would be what a reasonable person in the offeree's position would believe to be a time period for which they can accept the offer. Another situation where the offer terminates is if the offeree rejects the offer. Okay, I say I will sell you my coat for $10. You say no. You cannot come back later and say, okay, I've reconsidered. I will buy it for $10. In that case, you have simply made a counter offer to me because the original offer has terminated. Okay, a counter offer itself terminates the offer. So I say I will sell you my coat for $10, and you say I would buy it, but I'll pay you $8. Well, that's a rejection and counter offer. That counter offer terminated the offer. Now you have made me an offer. So I'm the offeree now, and I have the power of acceptance. Okay. Another situation would be if I extend an offer and then revoke that offer before the offeree or offerees have the ability to accept, okay, or before they accept, okay. I will sell you my coat for $10, and I say, you know what, I think about it, I need my coat. I'm not going to sell it to you. Okay, that's a valid termination of the offer, okay. The subject matter of the offer could be destroyed prior to acceptance. So I say I will sell you my coat, but I lay it on the chair, somehow it gets close to the fireplace, catches on fire, and is destroyed. Well, since the subject matter is destroyed before the offer is accepted, it is automatically terminated, okay? If the offeree suffers death or mental incapacity prior to the acceptance. So again, take my coat example. I offer to sell you my coat for $10, but before you can accept, you become aware that I've lost mental capacity, or that I've passed away. In that case, the offer is automatically terminated. And lastly, if the subject matter of the agreement becomes illegal, okay? If the government makes a law that says you can no longer deal in the type of fabric out of which this coat is made. In a situation like that, the subject matter of the contract, the exchange of this coat, has become illegal, and a illegal contract is void. So in that sense, it has not been, my offer has not been accepted, and the offer automatically terminates.
So to recap, different ways to terminate an offer. Revocation is the taking back an offer by the offeror before it's accepted. Revocation becomes effective when it is received or communicated to the offeree. Rejection, the refusal of an offer by the offeree that brings the offer to an end. If I say I'll sell you my pen for $5 and you say no way, that is a rejection. Counteroffer, a response to an offer in which the terms of the original offer are changed. Expiration of time, if the offeror set a time limit for acceptance, it must be honored. If no time for acceptance is stated, it must be accepted within a reasonable amount of time. Death. If the offeror dies or before the offer is accepted, obviously the offer comes to an end. Insanity. If the offeror becomes insane before the offer is accepted, the offer comes to an end. Number 6, waterbeds. Home furniture company advertised its waterbeds in a local newspaper. The newspaper mistakenly advertised the beds for $49 instead of $249. Must home furniture sell the beds at the advertised price? Defend your position by citing which legal principle is involved and how it applies. Do this now on your sheet. Must home furniture sell the bed at the advertised price? No. Advertisements, as a rule, are considered invitations to negotiate rather than offers. And this is the works cited for this assignment. I hope you learned something. Thank you very much, and have a wonderful day.